Okay, welcome today. Today is Thursday. Today is criminal law 100. When we say criminal law 100 means introduction to criminal law. Okay, welcome today. Today is Thursday. Today is criminal law 100. Today is criminal law 100. In other words, it means somebody saying no sound. You can hear. Can you get me now? Is the sound good? Yeah, I would like to know whether the sound is. Whether you getting me now? Okay, good. When for the purpose of this class and this section, criminal law 100 is just as the same as for me. I would say I would caption it as introduction to criminal law. So it's like this school is not about something you just got to go straightly into briefing cases and understanding briefing cases for those who are law students or criminal justice practitioners. They get you the cases, you read them, and then you analyze them and give your view. No, it's not what we're talking about here. This is a first thing in criminal law 100. One of the things I'd like to do first is to introduce you to the basic concepts, the principles and theories within the criminal law subject matter. The reason is you need to know all of the principles of criminal law, the various criminal law doctrines, various criminal law principles, theories, and then when you have that understanding and you grasp the concept, then you can go further now in doing advanced criminal law, like the one I will be doing subsequently, criminal law 200. But this is introduction. So one of the things I like to do in this particular subject, in this particular class, in this particular class, is to introduce the student to the definition of criminal law. I say the definition of criminal law. You got to know what is criminal law. You need to know what is criminal law first. By definition, it is the law that defines. It is the law that spells out. It is the law that develops crime and the punishment. That is the criminal. Sometimes we call it the substantive law. Sometimes we call it the penal law. Or some people sometimes will say the penal code. When you hear people saying the penal code, the criminal law, they are all the same. You hear the new penal law of Liberia, is that the same as the criminal law of Liberia? Is that the same as the substantive law of crime? So, you first of all, you cannot do criminal law without understanding what criminal law is. By definition, it is the law that defines crime and punishment. Period. It is a wrong sometimes. Other scholars have said it is a wrong that persecute. Let's say it is a wrong prosecuted and carrying a penalty, according to Smith and Hogan. For me, I like to say criminal law is the law that defines, that develops, and spells out crimes and their punishment. So under the criminal law, no act is a crime if the criminal law fails to define the act as a crime. In criminal law, there is no crime if that particular act, the criminal law fails to define it as a crime. It's not a crime. No conduct can be called a criminal conduct in the absence of a law that defines that conduct as a crime. That is the basic criminal law principle all over the world. You go to school in Great Britain, you go to school in America, you go to school in any common law country. This concept, you go at the international criminal level, is the same. No crime without a law. In other words, we can call it, in the legal doctrine for that in law is called nullum crimen sine lege. Don't bother about that. Don't be bothered about that. Yeah, it's just a concept I'm trying to give you. Don't be bothered about that. Just grab the concept. No crime without a law. So in the Latin concept, we say there is no of the penal law. So, the law that defines, spells out, and develops crime and punishment is what we call the penal law. The next thing is, what is the purpose of the criminal law in any state? Universally. You go anywhere to do criminal laws, you learn about all of these concepts. The purposes of criminal law. What are the purposes of criminal law? One of the first reasons for criminal law is for social control. If you don't have a law that keeps society in check, you obviously will have a situation where there will be a state of anarchy. Sometimes people call it anomy, the state of normlessness, the state of lawlessness, the stage that it is difficult for things to be under control. Survival is the fittest. That's what we call the state of anarchy. No one is afraid to be checked by a social order. So you have the strongest survive. And so one of the purposes of criminal law is to have social control. If there is no social control, there will be no normal life. An example is for many of you who were old enough to have experienced the 14-year civil conflict. Specifically, like you have the 1990. Survival was the fittest. You had a situation where there was no social order, where people respect specific norms of society, the laws of society, freedom of speech, movement. Those rights are not available. No one can account for your safety. You lucky, you survive, and that's it. That is what we call social control. To put that in order is called social control. So one of the purposes of criminal law is to have social control. The next one is deterrence. The reason in the world, before even the period of the Babylonian Empire, that witnessed the first set of written codes, criminal codes, to hold accountable people that commit crimes, up to the period of civilization, the European era, when the European society were during the stage of development and civilization was prospering. Those early stages, all of those periods, they had developed what we call the penal law or the criminal code. When you hear the criminal code, it's the same as the penal law or the criminal law or the substantive law or the substantive law of crime. The purpose of all of these laws from the history of law enforcement to present is to discourage people from committing future criminal crime. So in other words, if a person commits a crime, the reason you see people taking that person to court and to follow the due process to have them convicted is for them to be served, for them to serve their sentence in prison, for them to be incarcerated, for them to experience the wrong associated with the commission of a crime. If people commit crimes and they are not punished, it encourages them to engage in future criminal behavior. And then the person who committed the offense also is encouraged. And that is why we call specific deterrence, to punish the man who actually committed a crime so that he can be discouraged from committing future criminal activity. So that is called specific deterrence. When you make him as an example, while you are punishing him, for society to see that, watch out and see what is happening. This man is being punished today because he committed an offense. The reason society does that is because society wants to set an example that the others who are watching should be discouraged in the future not to commit such a crime. Even when the atmosphere presents itself for the commission of the crime, they will be discouraged because they saw that somebody had been punished. So we call that general deterrence. But all of them, for the purpose of this course, we will just say deterrence. So the second purpose of criminal law is merely to discourage, to punish in order to discourage people from committing criminal activities or criminal acts. Another purpose, you can get changed around, you can say punishment. The purpose of the criminal law is punishment. The reason we have the criminal law is to punish people who commit crimes. Because when they commit crimes, they have placed the society in danger. And when the society is in danger, then it threatens the stability and the security of the state. And that is why people are punished when they commit crime. So the purpose of criminal law is that. Another reason for criminal law is retribution. When you hear they say, sometimes it's in the religious sector or the biblical doctrine, they say, an eye for an eye and a tooth for the tooth. The Mosaic law. That is called retribution. Those days when somebody was your eye, you must be all the while. You take something and bust your eye. But as society became civilized, and then it became the collective responsibility for all to support a particular structure that will be responsible in return to protect all of us and serve us, which is the government. They decided to say, look, let the society take vengeance for us. So vengeance must be for society. So they call it societal vengeance. That is why when a person commits a crime, they will always say the man is against the state. When you go in criminal cases, you hear they say the republic or the people versus John Brown. It means John Brown committed a crime, and it is the society that represents the people that is prosecuting John Brown in the interest of public safety. So society takes vengeance. When you commit a criminal conduct, it is a crime against the state. The victim is just a private prosecutor, if that's a male. If the victim is a female, you say the private prosecutrix. So in criminal law, one of the purposes of this particular law is retribution, vengeance on behalf of the state and the victim. So in the contemporary society of criminal justice, it is the state that takes the responsibility to take vengeance on behalf of the state and the people or the person that is a victim of a criminal act. The next purpose of criminal law is incapacitation. When you hear incapacitation, it is that process in which you place the person who committed the crime in a position that they will be restrained and prohibited from living in the community among the people or the citizens. Because the concept is, if a person commits a crime, that person is dangerous to the safety and happiness of the community and the society. So the criminal justice scholars decided and said, look, when a person is a criminal or a person has committed an offense, let's place that person in an area that he will be restrained, not to get involved, not to be free to come in the community. And so he must have a place that he will be and be restrained. So we call it incapacitation. That's one of the purposes of criminal law. Sometimes we call it incarceration. When they say incarceration, it's the same as incapacitation. It is the same as imprisonment, meaning putting the man somewhere in prison to restrain his movement and keep him. Like when we have in Liberia, you have the jail, you have the prison compound. The prison compound is a form of incapacitation for people who are accused of crime and people who are convicted of criminal offenses. Because the notion is that allowing them to be free in the society will be dangerous to their victims and the society. And so that is the reason they place them in confinement. So incapacitation is one of the purposes of criminal law. You will read about most of the philosophy. These are, if you read the course, if we go further, maybe a year from now, or some months from now, and we complete this course, and we start introducing you to the course they call corrections. These punishments, these philosophy, these purposes of criminal law are referred to as sentencing philosophies or punishment philosophies or criminal justice correctional philosophies. They are concepts, they are beliefs, they are philosophical concepts or views that were developed and promulgated and that influenced generations upon generation before our time about the methodologies in which we can put people who have committed crimes into particular categories. The approach that we must apply against persons or individuals who commit crimes. These are the various philosophies that developed. They were not developed the same time. They were developed as time went by, in the event where people believe that one concept, one philosophy is not actually yielding fruit. That the issue of deterrence. So people decided to promulgate new philosophies, new concepts. So that's how you hear about something like rehabilitation, the next stage. The next stage that we talk about, which is the purpose of criminal law, is rehabilitation. The reason in the contemporary concept of criminal law today, not only Liberia, but the world over, the great United States that we copy from, Great Britain that we copy from, even Europe that we copy from. The purpose is simply that when the man commits a crime, there are certain factors responsible. You remember the last time I was discussing here, I was telling you about the nature of crime in society and telling you the three major factors responsible for criminal behavior. Now, it was based on these studies that philosophers believe in the criminal justice system. So look, people who commit crimes are 100% maybe not responsible. There are certain factors that influence their criminal behavior. So let the prison institution be an institution or a facility that will be able to address the factors that influence the individual criminal behavior. And so in the contemporary concept of criminal justice, the prison institution must be like a rehabilitation area, like how we have Don Bosco those days, LORC. The prison institution should be like that. They must have trades, various kinds of trades. First of all, when the person goes to prison, you do an assessment of their behavior. You find out what their educational capacity, their family background, their criminal history. Sometimes the man is not educated, he's not even an high school graduate, he doesn't have a trade. So in the prison institution, they identify certain programs and say, look, let's see what kind of program that will suit this guy. So they place you in what we call the screening, assessment, placement, treatment process. That screening, assessment, placement, treatment process is where you are screened, they assess you, look at you, they profile you, and then they say, look, that guy can be good in carpentry. My man, you want to be a carpenter? He said, yes. In that prison institution, he learns to be a carpenter. Maybe they sentence him to prison for 3 years. So the first year, he learns to be a very good carpenter. The following year, this guy who is a convict and now going through rehabilitation in the prison institution have become a professional carpenter. So in that prison institution, he can start facing his chairs and be feeding his family outside there. He faces the chairs, maybe he facing chairs for schools. The prison facility, the prison institution is providing the means, and maybe he produces over 200 or 300 chairs in 2 months' time. He gets about maybe 60% or 50%, and 50% goes to the prison. 50% of the proceeds comes to him. He uses that while in prison, and he's taking care of his family and feeds people out there. That is the fundamental philosophy that underlines the new direction in the criminal justice system that have brought the idea of rehabilitation. So one of the main purposes of criminal law is to rehabilitate people who commit crimes when they go to prison. It's not only to just incarcerate them, it's not only to just to deter them or to punish them or to serve as a deterrent. No. It's to work on their behavior so that the day they are coming out, they are coming as professionals, as straight people. And then society must be able to integrate them and accept them. And once society accepts them, it's highly difficult for them to go back into criminal behavior. So that's one of the purposes of criminal law. Another purpose is restoration. Some of the cases are when the person commits a crime and there is a victim, and the victim has lost property. The perpetrator will be asked, say, look, that man, you stole from the man, that man today is broke. That man is suffering now, he get no job. So here you have your money man. You ought to get a man for $50,000. So the judge makes a ruling, then you compensate. A restorative justice. Be able to compensate. Reparation. That restoration. Another purpose of criminal law is the expression of societal values. You can't commit crime and you left free. And then a time when a man commits a crime and he's allowed to go free, it encourages that man to commit the crime more. That's why we call it, in criminology, we call it the theory of differential association negative reinforcement. Don't bother with that. It's just something I'm telling you. When you start doing criminology, we talk about that in detail. I'm just giving an idea. What it means is that once you commit a crime and you are not punished, when people commit crimes and they are not held accountable, it reinforces their desire to commit more crimes, which will be negative, which will give a negative impact to society. Because this guy is not punished. He is not punished in order to discourage him. That's why you hear they say the punishment must fit the crime in order to discourage the pleasure that the man obtained when he was committing the offense. But when the man is punished, in order to outweigh the benefit that he received during the commission of the offense, then it falls under the theory of differential association positive reinforcement. That is, he's punished, he receives equal punishment that will discourage him from committing that crime in the future, so society is protected from future criminal activity. So it's a positive impact for society. Differential association, a positive reinforcement. Another purpose of criminal law is to establish the legal certainty and fairness. Criminal law is intended to make sure that it must show that indeed there is stability in the law, that there is law and order. The purpose of criminal law is not to abuse power. The purpose of criminal law is not to abuse the power that is given to you. The purpose of criminal law is to make sure that the right people who committed the crime are punished, not the innocent. The purpose of criminal law is not to abuse the authority given to a person to exercise control in the arena of social control. The purpose of criminal law is to make sure that people will have confidence that indeed there is a rule of law in that society. That's one of the reasons in our contemporary society for international investments. Most of the time international investors, the multinational companies, when they decide to go in any country, one of the first things they do is to read the report of that country, especially the human rights report of the country. They want to look at the rule of law. If they observe that there is a corrupt system, if they observe that the legal system, the criminal justice system, or the legal system is corrupt, they will never invest. They can't come there. Because they know a corrupt environment does not establish or maintain what we call a legal certainty. So the purpose of criminal law is to establish the legal certainty in that society, and also to conduct a system that is fair. No matter if I am a rich person and I go to court with a poor person, in the eyes of the law, that's why you see the symbol at the Justice Ministry, at the Temple of Justice. Sorry, that symbol that you see to the Temple of Justice is the Lord Goddess, Justice Goddess of the great Roman Empire those days, that they call Justitia. That female statue you see is the Roman goddess of justice called Justitia. She is the symbol of fairness. That is why you will see the face is tied with a cloth. They said justice is blind. Justice does not care about the clothes that individuals wear and come before the court. Justice is concerned in hearing the truth and listening to the evidence and make the decision on the basis of the facts and the evidence. That's why you see that symbol, the woman is blindfolded. So these are the purposes of criminal law. These are the purposes of criminal law. The next thing I want us to talk about before we close for the day that you need to know is the topic that has to do with the sources of criminal law. What are the sources of criminal law? That takes us to slide 4. What are the sources of criminal law? In other words, criminal law has its own foundation. What is the foundation? Where does criminal law come from? criminal law comes from certain sources. The first source of criminal law is the Constitution. The Constitution is the general law of any state, including Liberia. If you read the penal law if you read the Constitution of Liberia, you will read specific provisions of the Constitution. Let's look at specifically chapter 3 of the Liberian Constitution. If you look at chapter 3 of the Liberian Constitution, in substance, it's talking about the criminal law. But now you're going to tell you criminal law. For instance, the protection of due process of law. It says no one. Let's look at Article 21. A. Chapter 3. It says no one should be denied a right or a privilege or a property without due process of law. I'm just summarizing. Let me just paraphrase that. When you see that the denial of a right, the denial of a privilege, what can deny a right or a privilege? It's both criminal law and civil law. But in this context, without due process. Let's go to Article 21. The right to search and seizure. The right to legal representation by a counsel. What is that? It's about criminal investigation. It's about investigation where a person is accused of a crime. They need the right, they have the right to a lawyer. So the source, one of the sources of criminal law is the Constitution. The Constitution is the one that gives birth to all of the laws of the state. Any law or laws that violate the Constitution or that is inconsistent, in other words, any law that contradicts, let me say it another way. Any law that says different things from what the Constitution says, that law is inconsistent with the Constitution. And so under Article 2 of the Constitution of Liberia, the Constitution says, to the extent of the inconsistency of that law, it shall be declared unconstitutional. That is what Article 2 says. It says the Constitution is the supreme law of the land. The reason they told you that it is the supreme law of the land, it is the law that gave birth to even the state and the organizational structure of our form of government and democracy. So the first source of our criminal law is the Constitution. That is why this law is the most powerful law of any state, the Constitution. To be accused of violating the Constitution is a grave offense. Very grave offense. The organic law. So for the organic law, there will be a time we'll be teaching constitutional law. We'll tell you about the interpretation, how you interpret the Constitution. The various interpreting principles, the various principles you use to interpret constitutional law or the Constitution. You got a lot of different kinds of principles. But let me not confuse you with that, because that comes to that different subject by itself. You're talking about interpretation of the Constitution, the originalist perspective, the doctrine of harmonious construction. Don't bother about that. Don't listen to that word I'm talking. Don't worry. Don't be bothered. I just want you to hear something. So let's look at the second one. The second source of the criminal law is the statutory law. What does that mean, statutory law? In other words, when you hear statutory law, any law that the legislature passed is a statutory law. So the criminal code, before those days, there were no written codes. So they call it the common law. It has to do with the common law those days. The criminal code developed from the common law or case law those days. So the courts used to define what the law is and what crimes are. So we used to call it the case law. The judge made laws. Judges can make laws in the absence of statute. In the absence of laws, when particular issues come before them, they can make decisions in the absence of statutes and any codified law. They can make decisions, and those decisions are called judge-made laws. Until the legislature can go back and pass a bill into law, and then it becomes, that's the only way it will nullify that judge-made law. So those days, when Parliament decided to say, look, but then we have to codify the law. The people must know what is expected of them. Because one of the reasons for law to enhance its objectives is that the rule of law must be consistent regarding interpretation. In other words, the interpretation of the law must always be consistent. You can't say, when you commit this crime, this is the punishment, and tomorrow you say, when you commit this crime, these are the other punishment. No. Interpretation must be consistent. So that's the only way the law can enhance its objectives. So the legislature, they go to work and pass the law called a criminal code and say, when you commit this act, it will be a crime. And because it is a crime, this is the punishment for the act. Because the penal law now, mind you, as I said previously, the penal law general principle is that no crime without a law. And if there is no crime without a law, also there can be no punishment without a law. Every criminal law that defines an act as a crime must define the punishment for that crime. We call it nullum peona sine legis. That's a Latin phrase, clause for it. That's a Latin principle of law that is applied to them. They say there is no crime, there is no punishment without a law. So every punishment, there must be a law. The penal law must define that punishment. If the penal law defines an act as a crime, and it did not define the punishment for that crime, then of course it's not a crime. Then there is a defect in the construction of the statute regarding the criminal law. So that is why the criminal law defines the act as a crime, and then it defines the punishment for that particular act. And so the legislature, they go to work and pass the law. So the criminal law, one of the sources of the criminal law is legislation. Like our penal law was passed by the legislature. Even though the legislature needs to do both now in order to look at, because there are contemporary crimes now. Most of the crimes are committed on the internet. Most of the crimes are going on internet. Most of the dangerous crimes are committed on internet. You can get your investment that you do for all your money and saving for the rest of your life, and you make one mistake, somebody can just take it in the trickle of an hour. If you went on the website, you gave your particular and put your card that is attached to your computer, to your savings, and cyber criminals can just take it. We call them cyber crimes. Call that cyber crimes. So most of the crimes. So the legislature, in fact, will have to work on that to amend the penal law to what? To introduce new new acts that are considered crimes related to cyber criminality. The next source of criminal law is case law. I just was telling you that we call it judge-made law or case law sometimes, or we call it the common law. You know, our penal law developed from common law. Before Liberia did not have a penal code. It took time before we started to do a penal code. So the courts used to make decisions based on what? Case law, common law, judicial decisions. Then as time went by, it developed. Today we have stare decisis, the doctrine of precedence, all these things. Another source of criminal law is administrative law. Administrative law has to do with law that regulates administrative agencies about how they respect the rights of people. when an administrative agency had engaged in an act that violates the law in the community and it borders on criminal responsibility, like for instance, ecological crime or environmental crimes, while the agency can be dealing with that aspect of violation, but when it borders on criminality where the penal law defines it, it will leave it in and say, look, you're turning over to the appropriate criminal investigative authority. Another source of criminal law is customary law, traditional law. Our people have traditions. Like under the traditional law system, where you have traditional law, traditional marriages and what have you. Those days, under the common law system, in the traditional justice system, when you rape a girl, where you show love, you will go marry that girl. You will pay the dowry. You marry that girl, you will be compelled to marry the girl and pay fine. Those are all customary law. Those say that. But the criminal law developed now, you don't have to marry. You don't have to marry that child. You will go to jail. That's statutory rape, whether or not the child agrees. Okay. Another source is international law, the law that regulates the conduct of nations in terms of their relations with one another. In the international system, that's what we call international law. And international law has different kinds. Under international law, you have international human rights law. You have international humanitarian law. You have international maritime or commercial law. You have international criminal law. So they have different kinds of branches or different branches of international law under the international system. Another source of criminal law has to do with scholarly writings. Persuasive authority. There are scholars in the area of criminal law who write and give opinions. They write and give opinions. Their philosophical concepts and views. And nations listen to their views that have influenced the criminal law system. For example, our penal law today has certain things, we come to that has to do with defenses. Under the criminal law, there are conditions under when you commit a crime. You can have excuse. You can be prosecuted for the doctrine of insanity. Now, these concepts that are employed in the criminal law doctrines were concepts that developed by philosophers, scholars, who said some of the conduct of people that we consider criminals are biological. Let me give you one example. I'm not saying all instances, but let us ask the hard questions. Why would a 45-year-old man or 30-year-old man rape a 2-month-old baby, a 2-year-old child? He can only rape 4-year-old children. He can go around adults or women. Why? In Liberia, we say, oh, you get rid of the man. You deal with the man. But scholars of criminology, scholars in criminal justice, scholars in criminal psychology will say there is a problem with the man. Let the man be one, screen, analyze. Then you go for psychological evaluation. Whether he's normal. Is he a normal person? In criminal law, we call it mens sana, incorporea sano. Don't bother with that. Mens sana, incorporea sano. A sound mind in a sound body. A sound mind in a sound body. Mens sana, incorporea sano. So, but that person, you find out, suppose the man is an erectomanic. Because people who suffer from erectomania are people who have the uncontrollable desire for sex. And in many developed societies, what they do, they put them under chemical castration. It doesn't mean they're going to take out one of their testes. No. But they can put them under certain medication to reduce their drive. Or sometimes they can cut their veins, certain veins that will reduce the potency in them. But that level, the forensic psychologists and medical doctors and practitioners. But in an environment like this where we have no experts to analyze this particular person's behavior, we say, oh, let me know what he's doing. Some of them, there are people who commit these kind of crimes, they are not normal. But we have the sophistication to detect that, like the erotomanic. An erotomanic is somebody who has the uncontrollable desire for sex. These are people that can normally rape. Then you have the kleptomaniac. People with the uncontrollable desire to steal. Some of them, they got money, they don't care about it. When the person comes here, some of them, they just see their food, they get more food, but they say they just want to take it, don't take it. Like erotomania, the uncontrollable desire to steal. So these are some of the problems. These are biological problems. These are genetic problems that relate to the biogenic explanation of criminal behavior, and that have influenced the penal law of Liberia based on scholarly writings, philosophers who promulgated these views that influence the idea of criminal law. So let's stop there today. Next week, Thursday, we'll continue with criminal law. Next week, Tuesday, we'll continue with criminal justice. I hope you enjoy the class for the day. You can go, as we said the last time, please go on the YouTube page and then try to subscribe to the page, because as time goes by, that way we'll be producing the material, that way we'll be leaving the soft copy that people will actually be going for to download. This Facebook page is just the intro. But as time goes by, even though we're doing the sharing some materials, but it's from the YouTube page that we actually be able to use to share the material. So today is Criminal Law 100. Was the Criminal Law 100. Thank you for listening, and thank you for being part of the class. Good day. We'll see you next week. Thursday in Criminal Law class. Tuesday will be the introduction to the Criminal Justice class.